Good morning, everyone. My name is Adrian Lang. I'm a partner in our litigation group here in Toronto at Stikeman's. And on behalf of my colleague, David, and all of our partners, I'd like to welcome each of you today to the anti-spam presentation. We're thrilled that we can still invite you without violating any anti-spam laws. Following David's presentation, there will be a Q&A, and we hope to wrap up by no later than 9 a.m., so please do stay for Q&A. Some housekeeping duties that I have to attend to. There is a seminar booklet that contains a copy of today's presentation and some useful resources that David has directed us to for your benefit, and the profiles are in there as well. You'll notice at the front of the booklet there's a subscription card for a number of our publications. If you don't already receive them and would like to, please fill that out and leave it outside for our marketing people. We'd also appreciate it if you could complete the yellow evaluation form, which is also in the materials. And there are 2 resource tables outside with many publications of ours, so if you haven't already on your way out, please help yourself to anything that looks useful to you. During the Q&A, there are microphones available, so if you put your hand up, someone will bring you a mic, or you can just yell. So with no further ado, I'd like to introduce David. David is a partner in our Ottawa office. He's the head of our communications group, as well as our chief privacy officer. He's been practicing for over 20 years. He's a member, and I didn't even know we had all these groups in Ottawa, competition and foreign investment, privacy and data protection, and regulatory and public policy practice groups. He is formerly the vice president of regulatory law with Bell Canada and served as Bell's privacy ombudsman, and was previously counsel to the CRTC. He currently serves as the Special Digital Privacy Counsel to the Canadian Marketing Association, where he advises on a range of electronic privacy issues, including spam regulation. And he's the editor of our communications law blog, which you can sign up to receive. You can also find him on Twitter at ElderComLaw. He's going to today review the key elements and requirements of Canada's new anti-spam regime, including the recent revisions to Canada's electronic commerce protection regulations, and highlight some of the key implications of the new regime for companies doing business in Canada. And with no further ado, I would like to introduce David. Thank you.
Thanks, Adrian, and hold your applause. I haven't done anything yet. You may change your mind by the time we get to the end. Wow. Very full room. I'm still trying to figure out what's bringing you out here at 7:30 in the morning, whether it's the great breakfast or just fear of what this law could do. So we're not going to cover the waterfront today. I'll tell you that up front. Very confusing statute. It's over 70 pages. The law itself, we've got 2 sets of regulations, which I'll talk about a bit. We've got guidelines or bulletins that have been issued from the CRTC. We'll probably have more guidelines. So there's a lot of material. What I'm trying to do here is really just focus in on the parts of it that'll be most relevant, I think, to most Canadian businesses. And you'll see that will mean I'll focus on the core provision, the anti-spam provision. I will talk a little bit about installation of computer programs, which is part of the law, but won't spend as much time on it. And the idea here, I hope, will be to give you enough of an overview that you'd be able to identify potential issues for your clients, for your businesses, in complying with the law, and know where to go, where to take your next steps. So in a way, I think of this as kind of the double-decker bus tour. You know, you're in the new city, you don't have a lot of time, so you just get on the bus and you see things out the window, and maybe as you need to, you can go back to whatever really strikes your fancy. Okay, and I have a control. I have the remote. Okay, so first thing to get out of the way is it's called, or we refer to it as Canada's anti-spam legislation or anti-spam law, CASL or CASL. As those of us in the biz will say. And it's called that. That's the unofficial title. But everyone seemed to agree that this is a good title and this is what we'll call it. And the main reason for that is the actual title for the law is a staggering and incomprehensible 52 words long, which if we had more time, I'd read to you, but I usually have to take a break partway through. It's still not in force, but it is looming, and we'll talk a little bit about that. So I'm going to cover the overview of the law, the timing of coming into force. I will talk a little bit about, as I said, installation of computer programs, and then we'll get into the meat of it, the heart of the legislation, which is the anti-spam law. So what is this law supposed to be about? Well, maybe you've, like me, you've received an invitation for some companionship, or several. I seem to get a lot of these. And, you know, as much as the next guy, I think we all love to hear the expression, you to interest me as the man. But something tells me that not very much good would come of this, where I follow up with Maya, baby. Or I bet we've all had one of these. How many people have had an email that they've received, or you may have to check your junk mail folder to find these if you have a good spam filter, but from a bank, perhaps a bank you don't deal with, saying there's a problem with your card and asking you to follow certain links and provide them with some great information. And then, of course, there's the granddaddy of them all, the Nigerian scam. And this one is actually from Nigeria. So obviously, and if you look at the bottom, you know, I need this information from you. Well, what do you think he's going to do with that? So this is what the law was designed to get at. Fraud, the most damaging and deceptive types of spam. That was the target, but as we see, we may hit a bit wide of the target. So this is what the law does. This is the CASL in a nutshell. There's these three sort of pillars, if you will. So the first talks about a prohibition on the sending of commercial electronic messages. The general rule is you cannot send a commercial electronic message unless you've got prior explicit consent. That's the default. There's some exceptions and some important exceptions that we'll talk about, but that is the general rule. The second one, very similar, it's about installation of computer programs. So you can't install or cause to be installed on another person's or another entity's computer system, a computer program, again, unless you've got prior explicit consent. The final pillar is about a prohibition on alteration or rerouting of messages. I'm not really going to talk about this today because I've been really hard-pressed to find a way that a legitimate business would want to do this, would want to trick people into thinking they were sending email to somewhere where they weren't. But just know that that's there, and that is one of the pieces of the law. And obviously that's a piece of the law that's very much directed at the scammers and the fraud artists. So the short message, I guess, and we'll get into this in detail, if your business does any electronic marketing, or if it downloads software or any type of programs in association with its website, with a mobile application, this law is going to change the way that you'll have to operate in all likelihood. There are a number of related amendments that I'll just run through very briefly. Along with the substance of the law, there are some amendments to the Competition Act. They're really in the misleading representation space, and they just tweak things a little bit to make it a little bit more directly relevant to an electronic environment. So it talks in particular about fraudulent use of address information and URLs and that sort of thing. The other change here is to the Personal Information Protection and Electronic Documents Act. It removes a number of the exceptions to consent in that law for two things. One is what they call address harvesting. And this is when you use some kind of an automated program to troll the web and pull together email addresses that you'll then use as a list. That is no longer, there's no possibility that you wouldn't have to get consent to do that. The other thing is about hacking into somebody's computer to pull out email addresses, which is obviously not a good thing. The Telecom Act, there's a clarification in there, and I think this is an important one to mention, that there are two different regimes that the CRTC, and which we'll see is going to be the administrator, administers here. So on the one hand, they have telemarketing, that's under the Telecommunications Act. On the other hand, they will have the CASL. They will be administering the anti-spam law. And the amendments to the Telecom Act are really just to clarify that those are two separate entirely separate regimes, and the Commission can't use its powers under the Telecom Act to regulate unsolicited communications to regulate spam. And then finally, as I said, the CRTC is put in place as the main overseer of the law, and I think that's an important point. So what are the teeth? I put this one up front because I think it gets people's attention, galvanizes their resolve. So there are a couple of things to highlight on this slide. Obviously there's a full range of tools that the regulator has to enforce this law. Chief among them are some very substantial, I'll call them fines. The government, for constitutional reasons, calls them administrative monetary penalties. They're still a big whack out of your pocketbook, your bank account. And they are very substantial. We're looking up to $1 million for individuals, up to $10 million for organizations. And, you know, I think it's instructive here to talk about the CRTC and its approach. And I think if we look at what the CRTC has done with respect to telemarketing in recent years, I think we can extrapolate from that and kind of predict maybe how they will look at and how they will enforce the anti-spam legislation. So the CRTC, in the last, I'd say, 3 years, as you've probably seen, a number of you, has all of a sudden really upped its game in terms of enforcing telemarketing. They're much more active. You see well, not every day, but regularly you'll see notices from them. A lot of them make the papers about such and such a company has been found to be in violation and has been fined, et cetera, et cetera. So this week, there were two announcements of companies that are particularly large companies. One was fined $100,000, one wound up with $80,000 by way of settlement. They agreed to these amounts, which were much less than they might otherwise have been hit with, and they agreed to that so as not to go ahead and run the risk of actually having higher amounts imposed when the thing went before the CRTC. So something to think about. I hate to be alarmist. I know you probably deal with a lot of Chicken Little lawyers that stand in front of you and tell you the sky's going to fall and everything's going to explode, and I don't want to do that. But I do think we have to be aware that there's some real issues here. And I just say that because I know I talk to a lot of companies that they say, oh yeah, but this is really, they want the scammers, right? And it's legitimate business and nobody's been complaining and, you know, they're not going to go after it. I wouldn't be so sure. I wouldn't, if I was a betting man, I wouldn't put my money on that. The other thing to highlight here, I think, is there's a private right of action, statutory private right of action in here. There could be very low damages. It could be like $200 damages, but $200 damages that you don't really have to do a lot to prove. Just imagine that private right of action combined with a class action, and be afraid. I'll talk a little bit now just about all the various components of the law. And where we are. So I think what you need to know at the moment, I mean, certainly the law has been around for a long time. If you actually check the statute book, it's been on the statutes of Canada for over 2 years now, but it's still not enforced, which is a bit odd. Part of the reason it's not enforced is because when they started putting out the proposed regulations, particularly there's 2 sets of regulations you'll see. One of the sets, I think it was really corporate Canada really woke up and said, oh, wait a minute. This does way more than we thought, and this is really going to be problematic, and there was a lot of opposition. So we do have a finalized set of regulations from the CRTC, which I'll talk about a bit, but we had a set from Industry Canada. They were proposed, they met great opposition, they went back to the drawing board, they eventually re-released a new version just this January, and sought comments on it, and that's where we are right now. The other pieces are in place. The CRTC will be administering a spam reporting center where people can complain, and they'll collate the various complaints and then take action. They've already staffed up for it. There are people sitting in cubicles in Gatineau right now waiting to police spam. I don't know what they're reading the racing form now or something. I don't know. But so the regulations, once those regulations get finalized, the government will announce the date on which the whole shebang will come into force. The latest intelligence is that is most likely not going to happen now until the fall. They've got a number of issues that they're wrestling through that have been raised again and this time around. There is some slim possibility they could republish the final version of the regs just before the summer. But once you hit the summer, things more or less shut down. The MPs go back to their ridings, that sort of stuff. So if we don't make kind of late June, I think we're looking at fall. Depending on when that happens, I think the best intelligence now is you're probably looking at about a 12-month, give or take, window before it actually comes into force. So you will have a bit of lead time to deal with this law. That could be less, that could be more. It really depends on what time of year it winds up getting proclaimed in force. That's my understanding. Okay, so that's where we are. That's the general thing. So now we'll talk a little bit about computer programs, but not a lot. So as I said, it's part of the anti-spam law. It gets much less attention, and I'll run through it fairly quickly here today. But this is an important provision, and I guess, you know, how many of us have unwittingly wound up installing a toolbar or a program or something else on, I mean, and that's part of what this is about, making sure people are fully aware at all times what goes on their system. And in a lot of cases, in my cases, the things that I've wound up installing haven't been that big a deal. It's, you know, it's maybe a browser that I didn't really want, but nothing harmful, no malware. Obviously, there are much more nefarious examples of this. So what I would say to you by way of general comment is that this isn't just a prohibition that would affect software companies or technology companies. A lot of businesses, for promotional reasons and otherwise, will have features on their website that may incidentally involve some kind of download of a program. You know, if you've got an online customer service rep where you get a window that pops up when somebody is browsing your site, in order to affect that, often there's some software that needs to be downloaded to allow your rep to take control of the user's desktop. That would be often software that we downloaded. A lot of companies have mobile applications. The trick here is go and ask your technology people and make sure and dig deep, because it can be very surprising sometimes what you find out. When you're within a company, you know, sometimes we're all in our separate fiefdoms, and the technology people are doing all kinds of wonderful things that, you know, not even the marketing folks necessarily know about. So talk to your propeller heads, dig deep, find out what they're doing. So by way of quick run through here, so installation of computer program, I said the general rule is thou shalt not install a computer program without explicit prior consent. And if you have a program already that installed on a user's computer, you also can't cause that to send an electronic message. Yes, sir?
Definition of what's a computer system?
There is. And it's a very long definition. It's basically the same definition that comes out of the criminal code. So, I mean, it's a device or a group of interconnected or related devices, one or more of which contains computer programs or other data, or pursuant to computer programs performs logic and control, may perform other functions. A very broad definition. Now you'll see there are hopefully there are a couple of exemptions from this, which are kind of important ones. But this is the general rule and what you need to deal with. So here's some of the exceptions which were helpful, and these were lobbied for. In the first iteration, they weren't there in the law, and I represented a couple of clients where we went in and we said, well, this is kind of ridiculous if every time you run a bit of JavaScript, that counts as a program and you need to go through all this rigmarole. So accepted are things like cookies, which one might argue isn't conceivably a program anyway, because it's just a text file and it's not executable, but there it is, exempted. HTML code, JavaScript, operating system. So there's some here. There's also the provision that, as per the regulations, that at a later date they can add more to this list. But that's the essential rule. And then I'm going to go through these really hardly at all. But it's in your materials as a resource. Understand that when you're in the realm of installation of computer programs, there are two flavors and two different types of consent. So run-of-the-mill computer program, which I've called Express Consent Light, it's pretty basic. You set forward what the purposes are, who you are, you identify yourself. There's a certain information that you have to include, your address, etc. It's pretty basic. If, however, you have a computer that does, let's call them unexpected, more intrusive functions, If it interferes with user controls, if it collects any data off a user's computer, if it sends out messages without the user's knowledge, any of this list, and this is a summary of the list, obviously, that's in the law. Once you're into that box, you now have to get an enhanced consent, where you not only set out, who you are and what you want it for, but you also have to talk about the reasonably foreseeable impact of the installation on the user. And so it's a more granular sort of required disclosure. I note here on the slides I've used a kind of color coding here. So the orange indicates the CRTC regulations, and the green is from a bulletin. Sorry, as we go by. So, and just as an example, in the type of consent you need, and this is from a CRTC bulletin, this is in your materials. This is from Bulletin 2012-548. The Commission says when you collect consent for installation of a computer program, it has to be separate from anything else that you're getting consent from, and it has to be a clear opt-in, no pre-check boxes. So this is the example that they use, and you can see you've got separate positive check boxes for I accept the terms and conditions for the use of this website or the purchase of this product, and a separate box to say I agree to the installation of this program, and a separate box for electronic marketing, and I agree to receive such and such. And each of those has to be a separate positive affirmation, and they can choose between them all. This is what the CRTC says. So now, into the heart of darkness, maybe is the way to put it. It's really the core of the law, source of the most attention, and likely, I think, of most interest to business. This is the core anti-spam provision. So the general rule is, again, as I said, prohibited to send or cause to be sent a commercial electronic message, we'll talk about that in a minute, unless one of the statutory exceptions or exemptions applies. I will run through these. Or you have the express or implied consent of the recipient. And we'll see that implied consent in this law means something different than what it means in every other law I've ever seen. And the message has to be in the prescribed form. The key point here, I guess, is that the default is an explicit opt-in consent, and that puts this law on the opposite end of things from the telemarketing rules, which are now opt-out. Right? We've got a national do not call list, and we've got internal do not call list, but you can call somebody until they tell you not to. It's also very different than the law in the States. The so-called CAN spam law is an opt-out law. Again, you can send someone a commercial electronic message until they tell you not to. You will not be able to do that in Canada once this law comes into force. So what follows now is I've tried to structure the rest of the presentation in a kind of flowchart approach to give you a sense of the type of analysis, the key questions you have to ask yourselves, you have to ask your own people if you're within a corporate group. And the first key question, is the message a commercial electronic message? And I'm gonna pause for refreshment here. So, and this is obviously the first key threshold question, because if it's not a commercial electronic message that you're sending, then we can go home or we can go back to the bagel bar or whatever. Because I know there's lots of lawyers here, I've actually reproduced the text on the slide so you get a sense of exactly what we're talking about. So, a couple of points. An electronic message, very broadly defined, it's not just your grandfather's email, if your grandfather had email. It's a message sent by any means of telecommunication to an electronic address. It includes text messaging, SMS text messaging. It includes sending a recorded sound electronically to an electronic address, or a recording of a voice or an image. It would also include some communications on social media. I would say they would certainly include social media communications that are one-to-one. I think the better view is it wouldn't apply when you're just following somebody and it's more of a broadcast message. But there's still a lot of unanswered questions in the social media space. If someone posts something on their, on a Twitter account that comes up publicly, and a company then responds to that with some kind of a commercial solicitation, is that a commercial electronic message? Arguably it is. If somebody says, oh, my car just broke down or my tires blew out, and some enterprising garage owner said, oh, we got a special on radials this week. Is that a commercial electronic message? It may well be. Commercial activity is also extremely broadly defined. Essentially, any activity of a commercial character is commercial activity, whether or not it's done in expectation of profit. And finally, I think context is all important here. So it isn't even just about what you say in the message, but how it's presented, the prominence that things are given, the type of hyperlinks that might be included, even the parties that are identified in the message as sending it could all have some influence on a decision about what is and isn't a message. And the standard is reasonableness, but there's a real gray area here. And particularly if you think about electronic communications that are more in the general realm of promotion as opposed to a direct sale. I think we can all agree, if you send somebody a message saying, buy my waterbeds, that's a clear direct solicitation. But if you send out, a newsletter about the latest, sleep research or whatnot, with your brand on it, it's obviously a promotional tool. There's no direct solicitation, but is that a commercial electronic message? One of the debates we've had internally, because we're a business and we send a lot of you invitations to breakfast seminars and whatnot. Where's the line there? Is inviting you to a breakfast seminar a commercial electronic message? If we send you a holiday card in December, is that a commercial? If it's an e-card, is that a commercial electronic message? I think the better view, hopefully, is that it isn't. But there's a lot of speculation at this point. And again, I think if we look to the CRTC, maybe we can learn something. So they have a very similar kind of definition in the telemarketing rules about what is and what isn't telemarketing. In that case, it's about telecommunication for the purpose of solicitation. And there's a nested definition of what is solicitation. It's a very similar kind of test. And so I think you're all probably aware there was very high-profile cases a couple of years ago with 3 major wireless providers. They were actually using automated technology, which you can't use for purpose of solicitation. There's a prohibition on it unless you've got prior explicit consent. They sent out messages to prepaid subscribers whose minutes were about to expire. So the message, it was a recorded message, you pick it up, say, just to let you know, you got 10 days left before your minutes expire, you might want to top it up. And if you want to top it up, you can call us here. So the position of those companies was, this is really a customer-friendly message. We're reminding people that they may pick up their phone in 11 days and it won't work. And we want them to know that. And it seems highly artificial to just say, your minutes are up, too bad. It makes perfect business sense, obviously, to say, and this is how you fix it. The CRTC said, well, that's solicitation. And you violated the rules. And one of the companies wound up with a $1.3 million fine. Just saying. Yes, sir.
Is the CRTC actually reviewing that rule right now?
They are reviewing, yes, they've got a proceeding going about changing some of the telemarketing rules, although they are for existing business relationships in particular. The CMA has had an ongoing, I hesitate to call it a battle, but cause with the commission to amend that. So hopefully those rules will change. But the point here is that this is how the CRTC thinks. And these tend to be, in some cases, if you're a high-profile company, in many cases, I think they're looking to make some examples, unfortunately. So that's the broad definition. Big controversy here, a lot of unknowns. I should mention what we're hoping to get and what we've heard from government is we may get some additional, or we will get, hopefully, some additional clarity on how broad that definition is, how far it reaches, through some guidelines that will be issued jointly, hopefully, by the CRTC and by Industry Canada. The second question, key question is, now why is that? Did I move ahead? Oh, okay. I did move ahead. Sorry, the second question is, does the message fit within one of the statutory exemptions? So we know what the general rule is. We know now that we're talking about a commercial electronic message. So the next question is, does it fit within one of the 2 exceptions, or do we have implied consent, which I'll talk about in a minute? So there's 2 flavors, again, of statutory exemptions. One exempts you from all the anti-spam requirements. The other exempts only from the requirement to have prior consent, but you still have to meet form requirements. You still have to identify yourself in a certain way in your message. You still have to provide an opt-out, as we'll see. I'll run through these fairly quickly. There are some, a number of these exemptions are less relevant directly to businesses. The first ones are about individuals can send mail or electronic messages to people with whom they have a personal relationship or business or a family relationship. There's been a lot of squabbling about how you define that, and they made some revisions. It does become relevant, however, to business for those of you who would employ something like a forward to a friend kind of functionality, because there is another little provision in the law that says it's an offense to incite or encourage someone to violate any of the prohibitions in the law. So if you put up a forward to a friend sort of functionality saying, hey, you know, this you like this so much, send this to 3 friends, or send this to 3 friends and we'll give you a 10% certificate or whatever, and that person sends them to people with whom they don't have the requisite personal relationship or family relationship, there's some potential liability there that you encouraged or incited that. So something to think about. It's not, I mean, I think I've been recommending what clients need to do is put some kind of exculpatory language in that, you know, when they're making that offer to forward to a friend, you know, the fine print, obviously, you know, you must do this in compliance with the law or something, but how do you really protect yourself? It's not clear. And I'll point out that there was a recent Australian case, actually, where the Australian regulator sort of gave a sanctioned McDonald's for exactly this, and McDonald's did have language on its site saying you can only send them to people that, you know, you're allowed to send them to, and people didn't to get their free fries or whatever. And McDonald's, they didn't get fined, but they got sort of a stern talking to, and it was widely publicized. Another important exemption here, I would say, for businesses is a new exemption. It's the last bullet here. For business-to-business communications, this is a new exemption. So if you're dealing on a business-to-business basis, you have some kind of business relationship. There's no definition of just business relationship. We'll see later there's a definition of existing business relationship. So basically, if you have any kind of business relationship and you're sending messages on a business-to-business basis and they're relevant to what that business does or what that person does, then you're exempt. And you're exempt from both consent requirement and the form requirements. So the key there is to tailor it so it's relevant. You know, one of the things interestingly enough, when I took over as Chief Privacy Officer for the firm, I inherited an email account for the Chief Privacy Officer, which kind of ironically was full of spam. And one of the things, the most persistent spam messages that we get, so this is to a law firm, is, you know, offers to sell flashlights. I bet I get 2 a month to sell these flashlights in bulk in different sizes, and they're LEDs. I'm sure they're a quality product, but they're not relevant to us or what we do, and therefore they wouldn't fit within the exception. Another exemption that is perhaps worth talking about, there's 3, I guess. I'll talk about them very quickly. If you send a message to someone that you don't think is in Canada, or you have no reason to believe is in Canada, for instance, you're a US company, you're sending it to a .com domain, for all intents and purposes, you think that customer resides in the US, maybe they do, but they happen to be on a trip to Toronto for business and they access their email through their hotel. This exception makes it clear that if that's what happens, then you're okay, you're not caught. One of the most problematic parts of the regulations for me is this next bit. They've explicitly exempted through the regulations messages that you'd send to satisfy a legal or juridical obligation. So it's been a while since I was in law school, but my recollection is you don't enact an exception unless it would otherwise apply. So this suggests to me that but for this exception, they think that sending a legal notice would be a commercial electronic message. Hopefully that'll get it fixed. And then finally, as I said, there's a carve out here. It doesn't apply if what you're sending is plain vanilla telemarketing using telephone lines as opposed to electronic address. Then there's exceptions from the consent requirement only. These here, again, I won't run through them all, but they're very, this is kind of what you would expect, I would think, in many cases when you're dealing with the business. If someone asks you for a quote or an estimate and you provide them with that quote or estimate, that's surely not, something that you need to get a prior consent for. If you send warranty and recall information, this is all exempted. But again, I'd ask the question, why do they need to exempt this? Why would this be a commercial electronic message to send somebody a warranty information? Anyway, an interesting one that's just popped up that we think is going to be expanded was meant to help sort of the real estate agents and those sort of things, is if they get a referral from someone that they've done business with in the past, and the person says, oh, you should call Sally, she's about to sell her house, or you should email Sally, she's about to sell her house. This says you can do that once. Your first contact with Sally is okay without Sally's express consent, but you have to say, well, David referred me, and that's why I'm getting to you. Right now, this only applies to an individual. Only an individual can do this. My understanding is that will likely be broadened to include an organization. So someone can recommend to a broker firm that they can call or they can email Sally. So the third question, so once we've gone through those two, we know it's a commercial electronic message. We know none of these exceptions apply. So the next question is, do we have implied consent? And I think I told you that the way that term is used here is totally different than in every other law in Canada. Typically, of course, implied consent means consent that's implied through action. If you use my website, you agree to these terms and conditions. So when you use the website, that signifies that you agree to the terms and conditions. That's not what it means here. What it really means here, in my view, is deemed consent. If you fit within the following narrow scenarios defined in this law, you're deemed to have consent. But they do still use the term implied consent, which suggests that I can remove that consent. I can say, don't do this, take me off your list. That's not explicit in the law. Arguably, I think it is present, it's at least implicit. The onus in all cases, if you're relying on an exception, if you're relying on implied consent, if you're relying on explicit consent, the onus is on the company that's relying on that to be able to prove it. So you need to have records that indicate that these scenarios were valid at the relevant time, in case you get called on the carpet about it. So implied consent there's three main types of implied consent, and it's only these three, and if you don't fit in under these three, you don't have implied consent, even if people do other conduct that indicates that they're okay with it. So the first and probably the most important for you is an existing business relationship. I'll go through the material fairly quickly. It is in your materials. But the idea here is basically somebody that you've had some kind of a business transaction with in the previous 2 years for the most part. So for a lot of businesses, that might be okay if you're on that kind of a business cycle. On other ones, if it's buying and selling a house, 2 years, most of us don't move every 2 years. A car, bigger ticket items on a longer product cycle, this isn't really going to help. The other one, the other two, the first is the conspicuous publication of electronic address. If you go to our website and you pull up my page, there's my email address because I want you to contact me. But I want you to contact me about legal matters and business matters. I don't want you to sell me flashlights, right? So you can contact me at that address, provided, again, it's relevant to what I do and who I am, and provided I don't indicate on my site, I don't want any solicitations. Similarly, what we often call a business card exception. If somebody gives you their contact information, you're allowed to use it to send them a message. Commercial electronic message, again, if it fits within what they do and who they are, and if they haven't told you otherwise that they don't want that message. But again, and these are good exemptions, but think about how you would paper this. Remember, the onus is on you to prove it. So you've got an army of salespeople running around with various, having lunches and playing golf and doing whatever, and they've got these lists. Where does it come from? Where's the documentation about how they might fit within these exemptions? There are also some non-business relationship exemptions, and I know there are a couple of folks here from nonprofits and the charitable sector. Unfortunately, I'm not going to cover that today. But there are another set of exemptions, particular for this for that industry. So let's look at the existing business relationship really quickly. Again, this is all in your material, so you can go back and study it. The point here is a lot would fall between the cracks here. So if you look at the first one, you sort of think about, okay, purchase or lease of product, goods, or services. Okay, that seems to cover off a lot of things. If we brainstorm, we can come up with all kinds of things that it won't cover. As an example, a client who is an academic publisher. So they market to academics, to the professors who choose the books that go on the reading list. But the sale actually is by the student through somebody else. So there's a bit of a disconnect between who they market to and who buys. So under this definition, it has to be a purchase by the person to whom it was sent, from the person that sent the message. So that wouldn't apply there. The message was sent to a professor. The purchase was made by a student. So just as one example, and there are tons of other ones that fall between the cracks. And this is one of the fundamental problems with the law. When you put together a law that says all is prohibited unless explicitly allowed, guess what? The government isn't really very good at being omniscient. There are going to be some things that they didn't take into account. And as people like yourselves here this morning, evidence as we get deeper into this and people think about it a little bit harder, we're finding new things all the time that fall between these cracks. So, again, follow up with this and look and think about how this might apply to you. So we've reached the end of the essential questions, right? So let's say we've got a commercial electronic message. None of the statutory exceptions apply. We don't have implied consent. Well, we're back into the default bucket where we need express consent. The term isn't defined in the statute, but the CRTC has provided some guidance on what they think it means. Again, the officials, the focus was on clarity of intention. And they were even implying at one point that a kind of implied consent could be explicit consent, which just makes my head hurt. The CRTC said, nope, it's got to be absolutely clear. It's got to be separate from the agreement, and it can't be a pre-toggled sort of opt-in. You also, in making a request for express consent, there are form requirements. There are particular things you have to say in terms of, some of it makes sense, identifying yourself and what you're asking for consent for and why. You have to provide a mailing address, which is a problem for a lot of companies and online companies that don't really provide a mailing address. They're a virtual company and they operate in a lot of different places, so which mailing address to use? You have to identify on whose behalf a message is sent, and the CRTC has suggested if you're a broader enterprise with a number of business units, you have to identify each of those separately, even if it's common branding. And so then you think, okay, so I have to identify my 6 companies under the common brand in this message, and then do I have to give 6 mailing addresses for each of those? I mean, you're going to wind up with like 2 lines of actual copy, and 50 lines of logos and links and things. So this is very much, there's a lot of pushback on this, and we're hoping that this will be softened somewhat as we go forward. And as I said, there's also this requirement there not be any pre-checked boxes. Again, this is in your materials. This is in one of the CRTC bulletins, and this is their example. Prior, as this was moving along, people were saying, well, when I sign up new customers or when I get new registrations to my site, they have to register. I collect information. They have to positively agree to our terms and conditions or to our privacy policy, et cetera, et cetera. And so what we were saying was, okay, well, put that in your policy, put that in your agreement, make it prominent, maybe have, the last line just before they hit I agree, have the last line saying, I agree to receive commercial electronic messages, and I can opt out and da-da-da. No, the CRTC says, you can't do that. You can't bury it within it. It has to be a separate thing. So you see in this example here, the very last point is, I agree to receipt of commercial messages. And underneath it, you've got confirmed purchase under these terms. But the CRTC says, no, that's not good enough. You also have to have a checkbox, and they have to fill it out. Yes, sir?
Is there not a prohibition against sending out a request for express consent?
You're scooping me here. Yes. Yeah, it's a wonderful tautology, isn't it? Once the law comes into force, sending an electronic message to request someone's consent to send them an electronic message is in itself a commercial electronic message.
I guess unless you fall within one of the exceptions in business relations.
Right, right. And obviously there are lots of other ways to collect consent, right, as part of, and that's, you know, in a way that's a lot easier. If you're signing up a new customer, if you've got a new contract, you have opportunities to do things as part of that process that are a bit less daunting. But if you don't have those opportunities, it's a real problem. So the messages also have to be in a prescribed form. I'm sort of repeating myself here because that's what the rules do. Again, identification, contact information. There has to be an unsubscribe mechanism, easy to use, right in the message. This is kind of the de facto standard anyway. I think most of us, when we get messages from an organization, there's a line at the bottom, you know, the best practice is you're receiving this because, and then if you don't want to receive any more, click here. A good strategy is to not to make it binary, and a lot of companies do this. I'm sure some of you do this. So it's not just I want to receive commercial electronic messages or I don't. You give people a choice. So sometimes it's called opt down. So I don't want to receive you know, flashlight sales, but I would like to receive newsletters about, you know, scientific advances in lighting or you know, whatever. It was given them as granular choices as I want to receive breakfast seminar invitations, but I don't want to receive newsletters and I don't want to get invited to Leafs games because I'm a Senators fan or whatever. The final thing that I'm going to talk about, and I know that I can sense Amanda getting ready to 5 minutes. At the best conference I was ever at, they had them ticking down 10 minutes, 5 minutes, 2 minutes, and then there was a big sign that said, please stop talking now. Or no, it wasn't even please, stop talking now. So I'll be good. I'll be good. Transition, the final thing, and this is some good news. Once the law actually comes into force, and remember I said there'll be a bit of a buffer period. They'll announce that the law is going to come into force, and it will actually come into force potentially 12 months or so down the road. When that 12 months starts, there's a 3-year transition period where existing business relationships will be grandfathered. This still refers back to all those tests for existing business relationships. So my academic publisher is still going to be sort of out of luck. But if you had a relationship basically at any time, because the one difference here is it's without regard to the 2-year time period that applies to a lot of the other existing business relationships. If you have had that kind of relationship, a sale of a product or service or an interest in land or whatever with anybody, essentially at any time ever, and that in relationship involved you sending them commercial electronic messages with an opt-out and they never opted out, you will be allowed for the first 3 years to continue to send to them, provided they don't subsequently ask you to opt out. So you've got a bit of a buffer there. There are some companies that say, oh, I'm good with this because, you know, a stale list is no good to me and I recycle every couple of years anyway. So by the time I get to the end of this 3 years, I'll have a fresh list and everyone will consent and it'll be fine. A lot of other companies are saying, wait a minute, this is still a problem. And I'm still in this dilemma about how do I ask people for consent moving forward because I can't really do that electronically. So by way of wrap up, I put together a bit of a compliance sort of to-do list here for you to think about. Obviously, one of the first and most important things is to watch the space carefully in terms of legislative developments. Come to things like this, you know, read the blogs, keep up with what's going on the fightspam.ca website. We also, there are a number of clients that I keep kind of a watching brief on because there's a lot kind of moving in behind the scenes on this. Obviously sit down and do a full review of all your email or your e-marketing practices, what platforms you're using, how you use it, the type of things that you send out, how you obtain your mailing lists. If you use third parties to either buy lists or use them to send things out, obviously some due diligence is required there. Look through the contractual arrangements to make sure that you will continue to comply. Back to the telemarketing example, one of the $100,000 fine this week was about a company who itself didn't violate the rules but hired a third party to do telemarketing on its behalf, and the third party violated the rules, but they were still responsible. right? If they're calling on your behalf and it's on your dime, you're supposed to be in control, and you need to get them 6 ways to Sunday in the agreement to make sure, from due diligence perspective, if nothing else. If you can go to the CRTC and say, look, here's our agreement. We told them exactly what to do and they went offside, you're in much better stead than if you don't have those kind of provisions. Look at all the formats, make sure that they fit with the form requirements in the law. Unsubscribe, it has to be timely too. Within 10 days, if someone asks to be unsubscribed, they have to be unsubscribed. Look at your program installations, as I said, talk to the people in your companies to make sure you know what's going on. Ensure you've got records, whether they're for consent, whether they're to justify any of those exemptions that I talked about, and make sure you can find them. I don't know how many of you had this experience. Certainly I've had the experience in my days as corporate counsel where we were keeping records because legal said that you had to keep records. But when we went to go find them, we found out that they were in, paper copies in archive boxes distributed in stores throughout Ontario. Doesn't really help you all that much when you need to go find it. And maybe that seems extreme, but I've seen that happen again and again. So don't think it won't happen to you. And finally, take a team approach. Engage everybody within your team. Make sure marketing is there. Make sure legal is there. Make sure your technology, IT people are at the table so you can sort of brainstorm a bit. It's certainly to do this sort of inventory and then break into teams to try and tackle things. And that, I think, is the end of my spiel. Thank you very much.
Thanks, David. We're going to go to questions, and I'll start with a question. If you're a company that has bought the assets of another company with an existing client base, do you inherit the existing business relationship or start all over?
The good news is you do inherit it. They thought about this, unlike the case in some of our privacy laws, where it's not explicit, and a lot of companies are in this kind of gray area. It's explicit in the law that you do inherit whatever existing business relationship exemption might have been applicable to the target company. So that's good news.
Work for national retailer, and I wonder if you can comment on. If you can please comment on whether verbal consent is considered legitimate express consent.
It is. However, you need to prove it. So are you talking about like a point of sale kind of verbal consent?
That someone's signing up for a program.
Yeah.
The ER asks them whether or not they want to opt into taking up. Is that considered?
Yeah. Again, I wish I had clearer answers on some of these things. The CRTC has put out guidance. Originally, they said consent had to be in writing, which sounded a little old school. And they didn't make explicit provision for electronic forms, which is odd considering we're talking about electronic commerce and e-marketing. So they amended that, and they said it can be in writing, including electronic forms, or it could be oral, it could be verbal. So that's the good part. The bad part is that they said if you go with verbal, you have to make a recording of that conversation and retain it, or have an independent third party who can verify that went on. And that's goofy. And I don't want to be the apologist for the CRTC. That came out of their approach to people switching telephone providers. So there were rules that if you're switching a telephone provider and you called up and you said, I want to switch to so-and-so, they had this process that you had to record that call, which is fine if you're doing it on a call. It's not that difficult to record a call into a call center. But if you're doing it at point of sale, it was a bit ridiculous. So it actually, early on, and I think this is the way they're going now, I think the CRTC is starting to accept that there can be a blend of oral consent and written consent, and that it may be sufficient to use, business records to justify that. So it at one point it looked like, you'd say, welcome, to David's Hardware. Thank you for your purchase today. Would you like to go on our mailing list? The reason that we ask you for that is so we can send you offers and promotions. Our street address is the store, the building that you're standing in, and here's our contact information, and you can opt out at any time. May I have your consent? Thank you. Oh, sorry, can I record this? Or bring this guy over to listen? So I think the better view, I think they've sort of seen the light, and so now I think you can probably have something written on your receipt that discloses things, or maybe a sign. You can ask verbally, and then as long as you've got clear business practice of your cashier asks, and when they ask, they put this tick mark in the box, and you do audits to show that that's a regular practice, I think that's going to be okay, and I'm hoping we're going to see some guidance from the CRTC that makes that a little bit clearer. But I think that's going to be, I hope that's going to be the answer.
Who's that guidance expected? It sounds like there's so much room for interpretation and guidance, and when should we expect it?
Okay, the question for those, I guess, who are working remotely or watching this later is when can we expect guidance from the CRTC? You know, my understanding is they're talking. This is Industry Canada and CRTC. I think they have slightly different ideas. And so I think it's taking a bit longer than anticipated to work through the issues. At one time, I would have said we might see something kind of early summer. Again, I think that maybe that's a bit less likely now. It might be in the fall, and we don't really know what it's going to look like. I mean, these additional guidelines have been offered up really as a response to a lot of the opposition to what was in the regs and some of the exemptions that weren't, or the clarifications that weren't in the regs. And Industry Canada said, you know, that's really not proper fodder for regulations. We're going to pursue it by way of guidelines.
Very back there.
Would you be able to just go over you made a comment about Twitter and directly responding, and I just wasn't sure about the fact that Twitter's like a platform that all users sign up for, and you're not getting a direct message in a way from the organization?
Yeah, although you can, right? So, I mean, I have a Twitter account. Haven't been on it recently. But, you know, if you sign up for Twitter, you know that what you're posting is kind of public, and anybody could find it through search, you know, or through a hashtag. And you know that people who sign up to follow you are going to get everything that you post, whether it's about, you know, a substantive matter or, you know, your latte had the wrong foam on it that morning. But I think, so I think those kind of communications, I think that's clearly part of the deal. And when you sign up for a social media platform like that, that's what you get. And I don't think those kind of broadcasts or public interactions are covered. What I'm thinking about is there is functionality in Twitter and on other social media platforms where you can send a message directly only between parties. And that is an electronic address. Your Twitter handle is an electronic address, arguably, under the broad definition. So if I'm following you and I send you a private message, that's just a message between us, I think that's caught. And the scenario that I was trying to imagine with my garage example would be someone responding to someone that they didn't have any prior relationship to on Twitter, but, you know, had a feed come up every time somebody said tires and sent out a message. And I think for those of us on Twitter, I think we've all had those kinds of messages that somebody's obviously parsed words in posts we've made and then responded with some kind of a pitch.
I was interested in what you had to say about the...
You're getting a microphone, sir. Sorry.
I was interested in what you were saying about the opting down method for unsubscribing, and just kind of wondering what that might look like. So if, for example, instead of an opt-out of everything, you had, you know, 25 specific categories, I mean, would those 25 specific categories together have to cover the entire universe so that you can opt out? And is there something at some point where you know, it just gets too complex, like if you just make it too difficult by having too many categories? Or
yeah, thank you for the question, because there's an important maybe clarification here that I overlooked. I think when you're offering up that menu of choices, one of the choices, either at the very top or the bottom and prominent, is opt out all. So you have to give them the binary option, because some, you know, and frankly, from a marketing perspective, if people really, really don't want to hear from you, you probably don't want to send the messages anyway. But there has to be an opt-out all, and it has to be prominent. From there, the world's kind of your oyster. It really depends on your business and what you think, you know, people will respond to. Obviously, at some point, you do make it too complicated, and people will go, I'm going to just hit opt-out all. It's too complicated. But there's no hard and fast rule there.
Some at the back.
This is Canada only, is that correct? I work for an organization with customers a lot in the US and Canada, in the United Kingdom as well as Canada, and I send emails from here. Can we just assume that our American customers are completely exempt?
Yes and no. I mean, I guess there are a couple of answers here. You're sending these messages from Canada internationally. Unfortunately, the law applies. The law applies to messages sent from or accessed in
So there's
Canada.
Extraterritorial reach,
Yeah,
the world around.
Yeah, theoretically. And of course, you also have to comply, I guess, with any anti-spam regimes in those recipient countries. But this is a real concern for a lot of businesses, particularly those who are in this business, who are in the business of providing mailing platforms and those sort of things, saying that it will put them at a disadvantage internationally, because even if they're sending it internationally, they'll have to comply with Canadian rules.
I'm interested in a little bit the academic example you gave of, and I'm trying to think if the company I work for could be inculpated by that kind of legislation. So we have a cloud-based platform that allows our OEMs to rebrand and send messages and receive messages based on device characteristics. So it sounds like it's a communication, electronic message, but could we be inculpated in that because it's parsing from our domain?
And what's the nature of the relationship? Is it like a franchise kind of arrangement, or you're just
so we
provide
sell
the
to companies,
platform?
they rebrand and sell to other companies. And so messages come back from those other companies back and forth through our mail server.
But you're really providing the platform.
Correct.
Do you provide the content? Do you have any control over the content?
Generally not.
Okay. If your answer was no, that would be better.
We don't provide the content, we provide the format.
I think we need to drill down a bit further on that. I mean, there's a general exception, and I didn't really talk about it, but if you're what they call a telecommunications service provider, which is a much broader definition than we're used to under, say, the Telecom Act. So it doesn't mean you're a telephone company, it just means that you provide any kind of electronic platform. And so if you just provide the platform, if you don't have any role in selecting message recipients or producing lists, and if you don't do the content, then you're okay. If your role in terms of content is you may just offer up templates that are visual templates, that's probably okay. But I have some clients that are in this sort of game, and it's I think you're better served to have a look at the law, and anything you put forward template-wise, make sure that there's no possibility that it will come back to haunt you, and ensure in your agreements, obviously with your end customers, that you make it very clear what they're responsible for and what you're responsible for.
Thank you.
To the very back.
I'm just wondering about charities and whether solicitation of donations for charitable purposes would be considered commercial messages.
Yes, it is, and there are separate. Maybe if you want to talk about it afterwards, there are exemptions for nonprofits, but generally speaking, asking for a donation through an electronic message would be considered a commercial electronic message, and most of that stuff would apply, subject to the exceptions.
So the personal exemptions, like if you're contacting people you know already for sponsorships, that would fall under those exceptions, but
Yes.
there might be, but generally it's considered a commercial message for soliciting donations or sponsorships.
Yes.
Okay, thanks.
Let's do one more question. It's 9:05, and I'm going to volunteer David to stay after to talk
Thank
to you
you.
individually. Back there.
Good morning. I'm wondering about marketing to youth and children, and has the CRTC indicated whether it has any objection to consents received from folks under, let's say, 18?
You know that they haven't got there. I'm sure they will. I think in other spaces, I think the commission has actually looked for a valid consent has to come from somebody age of majority. Whether they'll go that way here or not, I don't know. As you probably know, this does dovetail a bit with privacy law as well, and the Privacy Commissioner of Canada, among others, has been on a real bandwagon about youth privacy. And some of the fallout from that, and I think companies would be well advised when they're dealing in that market, is to be extra careful, and any disclosures and consents that you do set up, you gear it to that audience and that sort of reading and comprehension level. So maybe go the extra mile in terms of how you set things up. But they're still fighting over what's going to be in the guidelines on the big picture. So they haven't, that I'm aware of, gotten that far. But it would not surprise me that they get there.
So we're going to wrap up on that note. It is 9:05. I know many of you may have more questions, so please do come and speak to David. Thank you so much for coming. I don't know about you, I do not feel better about this legislation, but it was very interesting nevertheless. And please stay. There's coffee, and as David called it, the bagel bar remains in the next room. Thanks for coming, everyone.